Thank you for that warm introduction. I think it's always fun when I have that bit there that says anti-corruption and responsible tax APPG, and I too often forget to put the word anti at the start when I introduce myself. I have to go, we're the good guys, I promise. So thank you for my full title. Thank you again for that introduction, and good afternoon. It is a pleasure to be here in a room with so many lawyers, legal services professionals, regulators, and representatives from academia, the judiciary, and beyond. Truly a room full of experts, or as I like to call it, Michael Gove's worst nightmare. Now, I'm not a legal expert myself, but I do have a long-standing experience working with journalists and civil society activists who uncover corruption, fraud, and money laundering. Far from being a white-collar issue that doesn't affect our day-to-day lives, economic crime facilitates the drugs being sold on our streets and also violent crime. It also supports despots, oligarchs, and kleptocrats who wish our country harm. And economic crime also leads to the impoverishment of many developing nations. Often, these harmful financial flows and the bad actors behind them are uncovered by the hard work of investigators. And these journalists and civil society activists often rely on whistleblowers to shine a spotlight on wrongdoing. Without these investigations, we would never know about the money laundering, tax evasion, and corruption that was all exposed in the Panama Papers, the Pandora Papers, or the Paradise Paper leaks. Without these investigations, we would not have learned how £4.5 billion of Malaysian state funds were siphoned off. Without these investigations, we would not have found out about the £3.5 billion moved into legitimate financial systems by Russian oligarchs through the Troika laundromat. And without these investigations, we would never have understood the full extent of the Post Office Horizon scandal. The list truly does go on and on. And yet stories like these too often never reach publication, meaning they never see the light of day. Time and again, wealthy individuals, white-collar criminals, oligarchs and kleptocrats use their financial might to muzzle free speech and, in turn, launder their own reputation. The financial threat of prolonged litigation is often all it takes to silence accountability and scrutiny. Strategic lawsuits against public participation are just another name for lawfare, legal threats, intimidation, or simply put, for bullying. And this form of bullying has been going on for many, many years. And Britain is shamefully the destination of choice for these lawfare tactics. Why are we allowing our legal system to be hijacked in this way? These legal threats effectively stifle debate around a wide range of pressing issues, which are all significant to the public. In doing so, I fear that they shield misconduct and conceal wrongdoing in such a way that powerful individuals behind these threats can often get away scot-free. While this foul play is unacceptable, it is also a tool that is only available to those who can afford the most expensive lawyers. There is not a level playing field. Legal intimidation of this sort is only available to those with the very deepest pockets. In Britain, we can be proud to have one of the most advanced legal sectors in the world, much of it being in this room today. But we are also a more plaintiff-friendly jurisdiction, where mounting a defence is a particularly costly and lengthy process. And we have, sadly in my view, become the libel capital of the world. The UK is worryingly by far the most frequent country of origin for cases of lawfare. The justification for this abuse of the legal process often goes as follows. Everyone has a right to representation, the law is a neutral profession, and the cab rank system means that lawyers have an obligation to offer their services to whoever needs them. I disagree wholeheartedly. In my view, when our courts are used to settle scores and quash scrutiny, lawyers are instead acting as hired guns. They're being used to advance certain ends, and lawyers and their regulators have an ethical responsibility to be much more discerning. Now, in 2023, the Solicitors Regulation Authority noted that solicitors are not simply hired guns in a warning notice about abusive litigation, which I welcome. Despite these remarks, the SRA, I feel, has failed to sanction a real instance of legal intimidation in a case you are probably all very familiar with. Also back in 2023, we learned that the British government had foolishly aided the infamous and now deceased Russian warlord Evgeny Prigozhin to sue Elliot Higgins, an acclaimed British journalist. Prigozhin had already been subject to UK sanctions for more than a year for his role providing support to the mercenary Wagner group in Libya. Now, despite this, the government issued a special licence to a British law firm, Discreet Law, to work for the Russian warlord. The case was taken in a claimant-friendly London, even though Prigozhin himself, under sanction, could not enter the country. In court documents, Prigozhin claimed that Higgins had accused him great distress and his character and reputation had been gravely damaged. As an aside, I think Prigozhin did a perfectly good job of his own reputation damage all by himself. So what did Higgins have the temerity to report? Something that was entirely true and already in the public domain, that Prigozhin was the leader of the notorious mercenary Wagner group. The proceedings against Higgins were eventually struck out. Discreet Law pulled out of the case a month into Putin's invasion of Ukraine, and the law firm has since closed, although its partners do now lead other firms that continue to operate here in London. In response to this baseless lawsuit, Higgins filed a complaint against the firm with the SRA. 2 years later, the regulator found that Discreet Law had acted appropriately in representing the sanctioned warlord, and that the case was not a slap. Even more astounding, despite multiple international sanctions designations, the SRA found no evidence that Discreet Law was aware that Prigozhin ran the Wagner group. And so the lawyers who engaged in this abusive litigation faced absolutely no consequences to acting as hired hands for an insidious individual such as Prigozhin. Now, Sarah Sackman KC, the new Minister of State in the Ministry of Justice, condemned this behaviour as intolerable in Parliament just recently. And she noted that journalists are the lifeblood of our democracy. And indeed, if this case isn't a slap, then what is exactly? It is hard to imagine a clearer case of an abuse of process. And the SRA's inaction shows how inadequate our current regulatory framework is. As it stands, law firms face no deterrent to using harmful lawfare tactics. The SRA has a fining power of just £25,000 for traditional law firms, which pales in comparison to those firms' resources. And the vast majority of cases reported to the SRA are closed with no further action. The few that make it to the Solicitor's Disciplinary Tribunal, as we know, are rarely deemed to be slaps. We must be far, far more robust in our response to these abuses of process. So where do we go from here? I believe there is a clear consensus in the Houses of Parliament on 3 points. Firstly, that lawyers and regulators must take their ethical responsibilities more seriously. Secondly, that we must create a much tougher regulatory environment where the SRA feel empowered to be much more bullish when cracking down on these suspected lawfare cases. And finally, we need anti-SLAPP legislation that goes beyond cases that only involve economic crime. I suppose that's very much where I come in. There is, I think, a real case of consensus that has broken out across the green benches and the red benches. The law is not a means to intimidate and bully, and current arrangements are insufficient to tackling the problem. Because this problem goes far deeper and far wider than one sanctioned warlord, as there are a growing number of billionaires, kleptocrats, oligarchs and businessmen who use their financial might to influence politics at the highest level. That's why it is all the more vital that we tackle abuses of our legal system, so no longer can individuals bully, silence and intimidate. So I suppose my remarks today boil down to one very simple message. We must all engage with the SLAPS crisis facing us and call for a much tougher response to dealing with it. We can, with a change in legislation, regulation, and culture, shake off our reputation as the lawfare capital of the world. This is a matter of public trust. If journalists and the ability to speak truth to power are the lifeblood of our democracy, then equal access to justice and the rule of law are certainly its precondition. Thank you.